On this morning's docket. That is case number 108333, State of Kansas v. Longoria.
May it please the court, I'm Reed Nelson and I'm representing Mr. Longoria, and I would request 2 minutes for rebuttal.
2 minutes is granted.
Your Honors, this is a capital case, charge capital, where he was sentenced to life without parole. It also involves a auto theft and a burglary of a car. I'm going to take the issues out of order and skip around, mostly so that I can start with some of the evidentiary issues and talk about the evidence. But I'm happy to move at any time to any issues that you have questions about. So with that, I'd like to start with the last issue, which is whether there was sufficient evidence to support the capital murder conviction. The capital murderer relied on the underlying crime of aggravated criminal sodomy or attempted rape. And our position is that there was insufficient evidence to support. I think that the prosecution's best argument is probably the aggravated oral sodomy. Looking at the case in the light most favorable to the prosecution, which is what we have to do, I would direct your attention to probably their best piece of evidence on that issue, which was a spot of fluid on the floor of the car that was identified to Mr. Longoria. The fluid being a mixture of the victim's DNA and Mr. Longoria's sperm. So from that, the prosecution had the theory that this involved an oral sexual situation that evening that she was murdered. 2 problems with that. Number 1, it cannot be gauged when that stain occurred.
But can that evening be eliminated? In the light most favorable to the prosecution, can the forensic evidence make us eliminate that?
No, Your Honor.
And so isn't that enough to be in the light most favorable to the prosecution, to be an inference the jury could have drawn that occurred that evening?
I don't believe so. I don't believe that there is any evidence to support an inference that it could have occurred that evening as opposed to a prior evening. To me, it's a complete wash. The expert testified that he couldn't tell. Essentially, I'm boiling his testimony down, but essentially, he testified that he couldn't tell when that was placed there. And there was evidence by one of the prosecution's own witnesses that the defendant had told him that he had had sex with this person, with this victim, prior to this date.
Can you help me with some facts about that statement?
Yes.
What do we know, first of all, about when the statement was made by Longoria to the witness, the friend? And second, is there anything in the conversation that pinpoints the time frame when the alleged sexual acts occurred?
You mean the defense's position on when the sexual acts occurred, or the prosecution's theory that it occurred that night?
What does the witness say?
Oh, the witness's testimony, I think, was pretty cursory. I think that he just said that the defendant told him that he had previously had sex with this victim.
So he does make it clear it's previous.
I believe he made it clear that it was previous. That was my reading of the record. Okay. You know, I could be mistaken, but.
And do we know? Can we tell when Longoria made the statement to the witness from the record?
No. There again, it was my impression from the record that it was prior to this. And you know, I think that was the whole. I was thinking about the change of venue issue in my mind as I'm talking about this, because my feeling was that was the whole reason why the prosecution filed motions and so forth, you know, that eventually made it out into the public about him being such a braggart. my feeling, I thought that the prosecution wanted people to believe that he was just bragging about having had sex with her previously. He was a braggart and it wouldn't be true. So maybe that's also influencing my thinking about why I thought from the record, that it had been a previous sexual encounter. But,
Is this one of the witnesses that he asked to provide him a false alibi?
it may have been, and I believe it was also a witness who talked about all of these people being at this quinceanera party and then not being able to have participated in this. And so sort of moving on a bit, Chief Justice, did you have a question?
You may be getting at this, but I was going to ask if you could give us all the evidence that you understand that the prosecution relied upon to show that there was aggravated oral sodomy besides this fluid on the car floor.
Well, I think that was all. I think that was it. I think that that's why my feeling here is that it was a speculative argument that I think that's it. And I'm sure the state's going to correct me when they stand up, but I believe that was it. And kind of the step two, the other major thing I think that can't really be ignored is when they swabbed this victim's mouth after this, they find DNA from a different man in her mouth. Okay, their theory was that this was aggravated oral sodomy, and she spat this stain originated from her mouth. The expert said that DNA would not stay in her mouth more than 6 hours. To me, that should cast some kind of a shadow, not only over the conviction or what the state thought occurred here.
That isn't entirely accurate. He said there was DNA from another man that was on the swab that was taken from her mouth, and one of the possibilities was contamination of the swab, so that DNA may not have been in her mouth. Isn't that what the testimony was?
True enough, Your Honor, that is exactly right. And that leads to the interesting proposition that we take DNA evidence, especially in murder cases, as the currency of reliability, don't we? I mean, they support cold case convictions. You can get a murder conviction based upon DNA evidence in a cold case if somebody doesn't have a good enough alibi. So that's correct. It is a theoretic possibility that DNA was somehow on cotton that was used to swab the mouth.
Or I think the example was given that she was at a party or an occasion where could have sipped on a straw from another person, drank from a bottle that was being consumed by a different individual. All those were possibilities that were given as to the presence of DNA in her mouth.
Well, those possibilities get vanishingly remote under the testimony of that expert, because it couldn't just be merely touching a straw. He said that straw would have to be in a man's mouth. Okay, let's work backwards again. The expert said this DNA would not have been in her mouth more than 6 hours. So I think she was picked up by the car at 10 o'clock that night. Working backwards, she was on an all-girls outing that day and that afternoon with her family, an all-women's outing. They tested 20 people to try to find out whose DNA this could have been, from lab technicians to people who were around her in her house, coming up with no matches. So I think that under that expert's testimony, that particular idea is extremely remote. And it ought to give pause to. It is entirely inconsistent with Mr. Longoria having done this act that they find a different male's DNA off the swab of the victim's mouth. If we're talking about oral sexual contact.
Explain to me what happens after 6 hours.
That it is moved, I think he was indicating that it's moved around, swallowed, moved around, disturbed, disintegrated.
And so it was still there 3 days later because she was
Right.
deceased and couldn't move
Right,
around.
I think metabolism has stopped these actions that would normally have it leave. I'm not quoting him verbatim here, part of this is just my thinking, but I believe that's what it was.
If, go ahead.
Okay, go ahead.
I was just going to ask, if we accept your position, what is the remedy in this case? Is this a typical insufficiency argument that you would reverse the murder conviction as well, or do we just say all it impacts is the sentencing and we don't reverse the...
Right, I would say it impacts the sentencing. I think that the capital murder, it would be premeditated first-degree murder, is what it would be without this, and that it would be a resentencing. And I think that the evidence for the attempted rape is even thinner. I think that the state in their brief is supporting that, that the intent comes from his texts to her. And then I think that they're choosing then any overt act that evening maybe supports the attempted rape. My problem with that is I don't know how you get something as specific as intentional intercourse from general texts. Even if those texts have a sexual interest, I don't know how that supports an attempted rape here. This body was fully clothed. Part of the problem, I think, in the prosecution's case, when we get to these details, is that they don't know what happened during this time period. There is a great amount of speculation and not much evidence. I felt like they had, evidence leading up to this, evidence of his efforts to escape and so forth, but the time period in between is very unknown. And then I would like to hit the issue of the lesser included offense instruction, issue number 3, whether there should have been a lesser of reckless second-degree murder given. There was no objection. However, this is where someone kills somebody, there's no intent to kill them. There, however, is an extreme reckless disregard for that person's life. As I just said, in this case, there is very little evidence of what happened, but the one thing that we do agree on is that there was tape involved. And the state, in their brief several times, indicates that tape was used to restrain her. I think that's something that was argued, that's something that is accepted. In addition, that tape may have gone around her face. Not knowing what the exact circumstances or the manner of her death were, the pathologist said he did not know. It is certainly as likely as anything that she was being restrained in a very reckless manner with indifference to her life, and that would justify an instruction on reckless second-degree murder.
She was asphyxiated because of the tape, is that what you're suggesting?
That's correct, Your Honor.
Is there evidence to support that, though?
There is as much evidence to support that as there is anything else that was theorized by the prosecution.
Isn't there evidence that the tape covered all of her airways?
There is
residue?
There is evidence, I think, that it went around her, it was going around her face in such a way that it could have covered her
Mouth and nose.
mouth and nose. I can't quote that exact testimony, but that was my impression from the record.
So even if we accept that, just that there was adequate proof of that, you're just saying that it's equally indicative of reckless and intentional conduct. Someone could have done that intentionally to murder her or done it recklessly to restrain her and she died.
That's correct. In which case, I would say that there has to be reasonable doubt. If those are equal, there has to be reasonable doubt as to which it was. And then we get to the jury instruction that says if there is reasonable doubt, they must choose the lower of the offenses. And I do not think that the skip rule applies to this situation. The jury did reject intentional second-degree murder. However, both second-degree intentional murder and premeditated murder have to do with a continuum of the same intent, which is the intent to kill somebody. This case and these facts are different. In terms of the support that we're talking about here, which is a circumstances showing a reckless disregard, there is no continuum of intent to kill there. Rejecting an intent to kill does not also reject circumstances like a reckless putting on of this tape that are different in nature. I am about out of time, and I will take my seat unless there are questions.
On the change of venue issue, there was a survey done, but in this case, there was no survey of a comparable site. Is that correct? You know, very often we have a survey of this area, and then they'll survey another area to which the case could have been transferred,
Right.
to show the difference in knowledge and prejudice. But that wasn't done here, was it? It was just to measure the prejudice in Barton County.
That's correct, Your Honor. I think that it was only a Barton County survey, and I'll just mention on the venue issue, our concern there is the front loading of this jury at the bond hearing when he's unrepresented and the press learns about his 13 prior felony convictions, and then the unsealed motions which violate at least the spirit, if not the letter, of the court's order that there be no extrajudicial comments made in the case.
Any more questions of counsel?
Yeah, I do, Chief. Getting back to the sufficiency, the manner in which the victim's body was desecrated, either during or following her death, couldn't that support at least the rape finding and perhaps the aggravated sodomy finding, in that the genital area, the groin area, was mutilated more or burned more than other parts of her body, suggesting that there was something to hide?
I see what you mean. I heard that argument. I read that argument being made that
Isn't that logical?
well, if that was the only part of her body that was burned, I would say that is a logical assumption that somebody could draw from that fact.
I thought it was pretty clear that it was. I don't want to get too graphic here, but it was more prevalent in those particular areas than other areas.
I don't know well enough to know. I don't know if the record is clear enough to say that. I know that there was an emphasis on that. I don't remember seeing testimony that it was in this particular groin area more than the rest. I know that there were comments that the groin area was burned, but I think that there was extensive burning of this body. So I'm not sure that that's a fair, speculation to make.
Don't we
I
know
don't think it's speculation. I don't think it's speculation.
I was going to say, don't we know from the coroner that they were unable to really gather any evidence from that area because of the severity of the burns in
Correct.
the groin area?
Yes, that's correct.
But we know there were other areas of the body that they were able to gather. some evidence, especially the face and head.
That's true. They did swab. They got the DNA swabs from the mouth. That is true. Okay.
DNA swabs from the mouth, but the underlying crime here was oral sodomy, correct?
Right.
So why would
Oh, I'm
somebody...
sorry. Yes, I misspoke. I had the DNA swabs from the victim's mouth. There were no. Yeah, that was all. It was just DNA. Those 2 DNA swabs from the victim's mouth is what I was referring to.
Okay, well, I had in my notes that one of the crimes alleged was aggravated oral sodomy,
Right.
and that you were saying that would be perhaps the prosecution's strongest case,
Right.
but her face was not burned because the oral area was not burned as much as other areas of the body which would have supported attempted rape or sodomy.
Right.
Correct.
That's right. Yeah, I was.
So I'm asking if somebody's trying to conceal evidence of their crime, they did not do as good a job with her mouth as other parts.
That's correct. If that were their intent, and if oral sodomy were involved, you might expect that the emphasis of that fire would be in a different place. Yes, I agree with that.
All right. Any more questions? Thank you, counsel.
Thank you.
May it please the court, Chris Elsliger appearing on behalf of the state.
Mr. Esliger, could you just explain a few factual predicates for me?
That's right.
First of all, who was the prosecutor at the trial?
Would have been Kevin O'Connor and Andy Bouch.
Okay, thanks. The other thing I wanted to ask about was the introduction into evidence of the photograph of the victim.
Yes.
How did that happen exactly, and then how was it used subsequently by the state?
My understanding was that it was introduced as the very first witness.
This is the
Just the photograph.
prior photograph.
Yes,
Drug-
pre-death,
Right.
excuse me.
Right. And my understanding is that the prosecutors anticipated they would need it for witnesses to use to identify.
But
The
was
victim.
it ultimately used
But
that
no,
way?
it wasn't.
And was it her mother was the first witness?
I believe so. And that issue strikes me as, the prosecutors can't see into the future. They don't know if their witnesses are.
Didn't they have a preliminary hearing here?
They did. I
Were
don't
there
think-
any witnesses that were used to identify the victim that did not already know her?
I don't know in the preliminary hearing.
Well, shouldn't the prosecutors have known that? I mean,
Well-
we don't know what evidence is
Yeah,
going to be brought in is a little disingenuous to me.
Well, I mean, in hindsight, you can always look back and say, well, yeah, they should have known, whatever. But, the prosecutors don't know going in, and they need to cover all their bases. The last thing a prosecutor wants to do is go forward with the case and find out that he left out a critical piece of evidence that would have been easy to admit if he hadn't just assumed that he wouldn't need it.
Where was the photograph during the trial?
I'm not sure. I don't know that it was ever actually. I think
Was it ever displayed to the jurors?
I don't think so. I think
Was
just
it
went
taken
back.
into the jury room for deliberations?
I believe so, but I don't know from the record.
It was admitted as an exhibit.
It was admitted,
Yeah.
but here's the thing. The one case that I found that seemed to be on point was the State v. Crum, and in that case, the court said, "Well, look, the defense, could have moved to strike the photograph." And same thing here. If the defense felt like the prosecution had improperly admitted the photograph and then hadn't used it like they said they would, they could have moved to strike it, and they didn't. They didn't take any action to object or strike it.
You're talking about after the conclusion of the case, then?
Yeah. I mean, if they got to the the conclusion of the state's case and they said, hey, they admitted that evidence, that photo, and they never used it, Judge, we want to strike that. They could have done that, but they didn't.
Does that mean it's not error or that it's harmless?
Well, I would say that the argument that it's error is waived. Ultimately, though, I think it's harmless. I mean,
By the failure of a motion to strike, by the failure to move to strike.
right.
Okay.
I mean, I think they waived any argument.
Unpreserved.
Yeah. But and then of course I would reiterate that I think it's harmless. I mean, I'm not sure what possible prejudice could have been suffered by this photograph that wasn't used.
I have another question. Could you address your opponent's argument on the in essence, kind of the equality of proof that he made earlier about the tape and recklessness versus intentional conduct?
Oh, well, as far as, and it's requiring an instruction for reckless second-degree murder, I mean, there's just no evidence to support that. I mean, what you would have to point to some evidence that would support that, and
The evidence to support intentional conduct was the things that we list off, for example, that support premeditation, that sort of thing.
Right.
And that was all circumstantial.
yes.
Okay.
I mean, the thing is hypothetically, could it have been reckless conduct? Sure, but you're delving into speculation at that point. There's no evidence of that. You have evidence of premeditation and intent. You have the texts. You have him picking her up. Yeah, I mean, you've got a lot of evidence from which you could infer intent and premeditation. You don't really have any evidence that you could infer reckless conduct from.
And the evidence from the text that shows premeditation and intent to kill as opposed to have sex with her is what exactly?
Well, I don't know there's anything in the text
That's what I'm
is
trying to get at. I
definitely
understand-
intent to kill, but
Excuse me, I didn't mean to interrupt you. That's what I'm trying to get to. When you say there's no evidence of recklessness, I'm just trying to understand what is the evidence of intentional conduct.
well, I think you connect the dots, the texts, and the picking her up and taking her away, and
That makes him the perpetrator.
Right.
And that makes him probably somebody who has had or wants to have sex with her. How does it make him an intentional killer as opposed to a reckless killer? That's what I'm trying to get to. And I mean, the tape going over her mouth and nose, let's assume that's what happened and that it asphyxiated her. What's the evidence that was intentional versus reckless?
well, I think the act itself of putting the tape over the mouth and the nose would be an intentional act and would clearly be intended to kill, because when you cut off someone's ability to breathe, the obvious consequences are going to die. And if he didn't intend for her to die, she would have struggled to breathe for quite some time. I mean, people don't just die from having their airway cut off. He would have been able to see that she was struggling. If he didn't want her to die, he could have taken the tape off. So I mean, to that extent, I think the evidence is much stronger for an intentional act.
So the tape is on your list. Is there anything else on your list that shows intent versus recklessness on the murder as opposed to these other things?
Well, no, I mean, I honestly, I just look at this case and just don't see any evidence of recklessness.
I understand that, but I'm not asking about recklessness. I'm asking about your case, not his case.
I haven't balanced out. I haven't made a chart of what one or the other. But I mean, I think that's clear. I mean, you look at all of the acts that happen. There's not one single piece of evidence that says, "Oh, here's the intent." I mean, this is all circumstantial, so you have to connect the dots.
That's my point exactly. It's all circumstantial.
Right.
And that's why it's not an answer to there's no evidence of intent to say, well, there's no evidence of recklessness. I mean, he's saying there's not enough evidence.
But to get a jury instruction, there has to be some evidence that supports it. And I don't know that there was any argument was presented at the trial to say, hey, here's evidence that supports a reckless
No, he
a
admits
reckless
that,
instruction.
but they didn't ask for the instruction.
And so then when we're looking at what's the standard of review here for the omission of the jury instruction, well, we've got to look for clear error. Okay,
Right.
So even if it was,
And that gets into the weight of the evidence and lots of other things, and I'm not even talking about that. I'm just talking about whether there was error, not the reversibility of it.
And again, I submit to you that I think that it wasn't error to omit it. I don't think there was any evidence presented that would support a reckless instruction. But even if the judge should have given it, I mean, I don't think you can look at this case and say that there's any kind of probability the outcome of the case would have been different had he given that instruction. I mean, the jury was instructed on lesser includeds of premeditated and second degree. And they not only found premeditation, they found intent, and they found the during the course of the sexual crime to make it capital murder. So I would argue that the escape rule would apply.
Counsel stated during argument that the state doesn't know really what happened between the two time periods where you have the defendant. And I was a little confused myself about the state's theory about how the victim died.
Well, you're right. We don't know. No one knows except for Ada Longoria. But we do know that she died. She's 14 years old. She didn't die of natural causes. Someone killed her. So who did it? I mean, obviously, Alan Longoria was the person who picked her up in the car. He was the last person seen with her. His semen with her DNA was discovered on the floorboard of his car, and that's a pretty strong connection there. You can't really dodge that. And then, of course, he asked people to lie for him to make up an alibi for himself. And then when the investigation started focusing on him, he stole the car and tried to flee, which is, I think, pretty clear consciousness of guilt. So we know, I think, that Adam Longoria killed her. We don't know exactly how it happened, but we know that he did it. And like I said, when you connect the dots and you connect all the inferences, there's evidence to establish, premeditation and intent. Now, opposing counsel's arguments that he made up here about the sufficiency of the evidence would have all been good arguments at a closing argument before a jury, but we're beyond that now. The jury has heard all of that and has resolved the conflicting evidence and the questions in favor of the state. So now we have to look at the evidence in the light most favorable to the state. As we set forth in the brief, you connect all the dots, and it's there. The evidence is sufficient.
As I understand a lot of his argument, he was addressing what ultimately was the sentencing issue. And that was why this was such a severe crime that would warrant the severe sentence. And that's what had led us into the discussion about aggravated oral sodomy. And if I can characterize correctly what he was saying, he was inviting you to tell me what evidence there was to support that crime besides finding this fluid on the car floor that included his sperm and the DNA from the victim.
Well,
So this would be your chance, sir.
that clearly indicates, semen, sperm only comes from sexual activity. Her DNA was mixed in it. So there was obvious sexual activity between Longoria and the victim. The expert testified that it was possible that there was oral sex and she spat it out. So there's the evidence supporting that
I'm
theory.
sorry, you trailed off right at the end of that sentence, and I didn't hear what you said.
The expert, in testifying as to why the semen with her DNA mixed in it was on the floorboard of the car, testified that it was possible that he performed oral sex, he had forced her to perform oral sex, and she spat it out on the floorboard of the car. And that's evidence that the jury heard that they could take in, and they could decide whether that was a rational, logical inference to be drawn from that evidence. The other thing is, this girl was 14 years old, so any sexual activity between him and her was rape. So I think you've got that in there too for the attempted rape. She was taped, she had duct tape restraining her, which I think is evidence of force, which would also support the attempted rape. So those are some of the dots that the jury was allowed to connect. And the jury just drew reasonable inferences, just like we all would, and came to this conclusion. When you look at it in the light most favorable to the state, that is a reasonable, rational conclusion that the jury could find beyond a reasonable doubt.
Did the state make a post-verdict election to have of which of the underlying crimes would support the capital murder for sentencing?
I do not know that. That didn't come up in the arguments of opposing counsel in the brief, so I don't know.
So we don't know why the judge chose the one she chose.
No, it may be in the record, but as I stand here in front of the podium, I don't know. Okay, and if there are no further questions, then I would conclude my argument and ask the court to affirm the convictions and sentence.
Any more questions?
I have one. The Attorney General's office prosecuted this,
Yes.
and the AG's office opposed the change of venue.
Well, I assume so. I would have to go back and look at the record, but the venue wasn't changed, so I presume that it was opposed.
And what was the AG's opposition to change venue from a locale that had demonstrated 100% knowledge of the case?
Well, I think just in principle, I think there's a general belief that these crimes should be tried in the county.
Well, that's constitutional,
right.
but obviously that's constitutional.
And that's why, because to let the community make the judgment, the jury of the defendant's peers from the community. I mean, logistically for our office, I mean, we're coming from Topeka, so there's no.
That's the point I'm getting.
Yeah,
Usually we have a prosecutor that doesn't want to travel to
No,
another
I think
location.
it's a matter of principle that it should be, the trial should be within the community where the crime occurred.
But it's also a matter of principle that the trial should begin with all 12 jurors having a presumption of innocence.
Yes, and I don't think that the venue study that was done established that the jurors did not. I mean, it didn't. I mean, it established that people in the community knew about the case, which would be understandable given the news media coverage. And they had some preconceived notions, but the United States Supreme Court said that preconceived notions is not enough. I mean, you have to be able to show that the jury could not set aside those preconceived notions and decide the case impartially. And of course, the survey respondents were never asked that question. And so then you go to voir dire and you look at voir dire, and I think that you can read through it and see that yes, they were able to find 12 people who could sit fairly and impartially and decide the case. And I just as one last issue is I think it is a bit disingenuous on the defendant's side to argue or to complain about the media publicity when he was responsible for a large part of it. I mean, he actively sought out interviews with the news media even after the judge had admonished both sides to refrain from extrajudicial comments, and he, even while he was in jail, engaged in a telephone conversation or a telephone interview. So I think to any extent, I just think it's wrong for him to get up and argue now that, hey, media publicity denied me a fair trial because, if there was any error, he invited it. Although I would submit that when you look at the voir dire, there was, the jurors were all impartial.
Any more questions?
The motion to change venue wasn't even renewed after voir dire, right?
Again,
Okay.
speaking from memory, I don't recall.
Okay.
Anything else? I see none. Thank you, counsel. You're reserved 2 minutes for rebuttal.
I'll just answer two of the discussion questions that came up. I think Justice Biles asked specifically how she died or what was the manner of her death. And I'm looking at the state's brief, and I think that we are all agreed that they do not know. Their best speculation is, on page 29 of the state's brief, they were talking about the tape, and he writes, after he talks about the tape, she was restrained with duct tape, and then a few sentences later, her death was the result of strangulation or a similar act of intentional asphyxiation. So their best guess is, because there were no gunshots or other things, that it was a result of the application of this tape. And, so that's also what we are talking about.
I don't read that sentence to be restrictive to tape. It says to me strangulation. That's why I asked.
Okay.
Because in my notes, I was actually thinking that it leaned more on the strangulation, but what you just read is strangulation or restrained with duct tape and asphyxiation. So I think those two things are in play. Not just the tape. I don't think you can go there. Well, I mean, it doesn't seem to me like you can go there.
Oh, I see. So that.
What do you think?
Well, that's why I thought that that's what they were getting at.
Doesn't strangulation, isn't that different than asphyxiation with the tape?
Yes,
Okay.
it is. It is. Right. They said, you're correct. They said both or either. I don't know what the evidence for strangulation would be. I guess the lack of other evidence is where they're getting at. And then Justice Johnson mentioned the venue. I don't think the prosecution voiced an objection to the change of venue when that discussion came up. I think that the defense was angry that the prosecution had filed these unsealed motions and it had gotten into the press. And I think the prosecution, in fact, said, well, the remedy is not to dismiss the case. The remedy, if there is going to be one, would be to change venue or do something else. So,
Along that line, Justice Byers questioned that the defense did not renew the objection or the motion for change of venue after the jury was impaneled.
that may be correct.
And does that preclude us then you know, and recently we've said it's a two-part equation or two views. One, the presumed prejudice, and the other, actual prejudice as revealed in the voir dire.
Right.
And so without that objection, that takes that second view out of play, doesn't it?
Well, that's correct. That's correct, Your Honor. We cannot show actual prejudice. It was not renewed.
And there's no dispute that the victim died before the gasoline and the desecration of the body.
That's correct. Yeah. Okay. Thank you, Your Honor.
Any more questions? Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.